Good evening and welcome to Courts Today by Livelaw. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. Starting with a very important update from the Parliament. Today, on the 13th day of the winter session, the Lok Sabha has passed the three revised criminal law bills, namely the Bharatiya Nyaya Sanhita, proposing to replace the Indian Penal Code, the Bharatiya Nagrik Suraksha Sanhita, proposing to replace the Code of Criminal Procedure, and the Bharatiya Sakshya Sanhita, which seeks to replace the Indian Evidence Act. The bills were passed along with certain new amendments moved by the Union Home Minister Amit Shah. One of the amendments relate to giving exemptions to doctors in cases of death due to medical negligence. These bills passed the Parliament's lower house on Wednesday afternoon amidst the suspension of 141 opposition members of the Parliament from both houses. The members of the ruling Bharatiya Janata Party and its allies have defended the bills, saying that while the extant British-era criminal laws are centered around punishment and deterrence, the proposed bills shift the emphasis to justice and reformation. But with concerns raised previously by opposition leaders such as Adhir Ranjan Chaudhary and senior advocate Kapil Sibal, they have highlighted potential violations of human rights and inadequacy of safeguards against excess by law enforcement agencies. The Supreme Court has initiated contempt proceedings against a litigant for writing a letter to the President of India, intentionally suppressing an undertaking given by him to the court. He had filed an appeal challenging an order of the National Green Tribunal Western Zone that upheld decision of Goa Coastal Zone Management Authority to demolish his alleged illegal structures. These structures include construction of a restaurant, ground floor, and apartment on first and second floor. He challenged the NGT order before the Apex Court, arguing that it was passed without giving any heed to the pending application for regularization filed by him. He had given an unconditional undertaking before the top court in August, saying that if his pending application for regularization was rejected, he would remove the subject structure. And this application was rejected on 15th September. The court took serious note of the fact that despite the rejection, instead of complying with the undertaking, the appellant addressed a letter to the President of India, making a grievance that the court is likely to dismiss the present appeal. In doing so, he suppressed the facts about his undertaking and chose not to disclose the various orders passed by the court. The bench of Justices Abhay S. Oak and Sandeep Mehta observed that newspaper publicity was also given to the office memorandum issued by the Government of India based on the letter written to the President. When the appellant pressed an application to withdraw the present appeal, the court observed that the intention was obvious, that he wanted to back out from the undertaking given to the court. The court was of a prima facie view to initiate both criminal and civil contempt proceedings against the contemner. He has been asked to be personally present on the relisted date of 8th January. The Madras High Court today rejected bail to Enforcement Directorate Officer Ankit Tiwari, who was arrested by the Tamil Nadu Vigilance and Anti-Corruption Wing for allegedly collecting 20 lakh rupees bribe from a government doctor by threatening to reopen a case against him. Ankit was arrested earlier this month by the DVAC. Tiwari had argued that as per Prevention of Corruption Act, an officer could be arrested only for doing or forbearing to do any official act or forbearing from doing something in the exercise of an official position to favor someone. He submitted that in the present case, no case had been registered against the doctor nor any case was pending against him. Thus, he claimed that initiation of criminal prosecution was with malified intention. Challenging the bail plea, the state public prosecutor submitted that Ankit was arrested with due evidence, that several top officials of the Enforcement Directorate were involved in the bribery case, and only further investigation could bring out more details. It was also informed that voice recording and the video recording seized from dashboard of the car showing Tiwari taking a bribe had to be analyzed. Justice V. Sivangnanam of the Madurai bench today dismissed the bail plea moved by the officer. The Chhattisgarh High Court has pointed out a severe flaw in our society and has addressed it. It held that the entire society of human race needs to change dialogue at home so as to ensure discrimination based on skin color can be eradicated. The division bench of Justice Gautam Bahaduri and Justice Deepak Kumar Tiwari was hearing an appeal filed by a husband challenging order of the family court where the husband had filed an application for divorce and it was rejected. The husband alleged that his wife deserted him and did not come back to join the conjugal company despite serious efforts. He stated that after deserting him without any reason, she was also claiming maintenance. On the other hand, the wife pleaded that she was subjected to torture by the husband and was driven out of her matrimonial home, that abuses were hurled at her by the husband, ridiculing her for her dark skin color. She also complained that the husband physically assaulted her when she was pregnant and wanted to remarry. After hearing the witnesses for both sides and evaluating the evidence produced by both parties, the court was of the view that reasons assigned by the wife to leave the company of the husband seemed more logical. While dismissing the husband's appeal, the court said that no husband can be given leeway to part company of his legally wedded wife only because he does not like her dark skin color. The court referred to a study which indicated that people prefer having fair or light-colored partners. It significantly called upon the entire human race to change dialogues at home so as not to promote skin color-based discrimination and ensure people with dark skin color are not ridiculed or discriminated against. It is said that justice delayed is justice denied. Indian judicial system faces various challenges that contribute to prolonged legal proceedings, impacting the timely delivery of justice. One such case has come to light from Rajasthan. The Rajasthan High Court has expressed shock over a 1981 suit still stuck at defense evidence stage. The suit was originally filed before the Court of Sub-Divisional Officer Rajgarh in 1981 by the petitioners for declaration and permanent injunction against the defendants. Even after 20 years, the suit is still at the stage of defense evidence due to repeated adjournments sought by parties and granted by the Revenue Court. Recently, the petitioners approached the High Court seeking a direction to decide the suit within 6 months. The single-judge bench of Justice Anup Kumar Dhan came down heavily on the long pendency of revenue suits in the state. He said that now the time has come to change the old mindset of litigants that cases are filed by the grandparents and the judgments are heard by their grandchildren. Time has come to get out of the adjournment culture. While disposing of the matter, the court mandated the concerned sub-divisional officer to decide the suit within 6 months without granting any more unnecessary adjournments. Consequently, High Court also asked the Chief Secretary to constitute an arrears review committee to monitor the progress in the oldest pending revenue cases every 3 months. And the Chief Secretary is to submit a compliance report within 6 months about steps taken for speedy disposal of old cases. And now let me tell you, the Delhi High Court has today reserved order on the interim relief in a defamation suit filed by Trinamool Congress leader Mahua Moitra against BJP MP Nishikant Dubey and lawyer Jay Anant Dehadre in connection with cash for query allegations. As you know, Dubey wrote a complaint to the Lok Sabha Speaker alleging that Moitra purportedly took bribes to ask questions in the parliament. Dubey claimed that the genesis of the said allegations was a letter addressed to him by Dehadre. In an interview with the Indian Express, she had accepted the fact that she had provided her parliament login and password details to Hira Nandani. However, she had refuted the claim of receiving any cash from the businessman. During the hearing today, the counsel appearing for Dehadrai made a reference to para 68 of the Ethics Committee report, saying that it clearly reveals that there was a quid pro quo between Moitra and Hiranandani, due to which she was even expelled from Lok Sabha. The court then reserved the order on Moitra's interim injunction application and asked Dubey and Dehadrai's counsel to place on record the relevant portion of Ethics Committee's report. In another important update, the Bombay High Court today issued notice to the Attorney General of India on a PIL challenging the exception from disqualification granted to MPs and MLAs under the anti-defection law in event of their political party merging with another. The PIL filed by Meenakshi Menon, founder trustee of NGO Vanashakti, challenges the exception to legislatures from disqualification on ground of defection in case of merger of political parties. It argues that paragraph 4 of 10th schedule of the Constitution allows legislatures to defect and breach their social contracts with the voters who vote based on manifestos of political parties. Such defections undermine the fundamental structure of the Constitution, which upholds representative democracy in India. The PIL refers to the 2022 Maharashtra political crisis as an example of the consequences of group defections, asserting that such actions have become ingrained in political culture, eroding voter trust in political ideologies. A division bench of Chief Justice Devendra Kumar Upadhyay and Justice Arif Doctor sought the response of the central government to the petition within 4 weeks. And now let me tell you, a man has moved the Punjab and Haryana High Court challenging an order of the Sessions Court framing charges against him under Section 124A of IPC, that is for sedition. The allegations are that he used filthy language against India and raised the Pakistan Zindabad slogan. After the video of the alleged incident went viral, the police registered the FIR and arrested the accused Irshad, who is a labourer by profession. In October this year, the Sessions judge framed the charge for committing sedition. Further, summons were issued to the prosecution witnesses for March 2024. The accused filed a revision petition challenging the Sessions Court order, which was heard by the single bench of Justice N.S. Shekhawat today. The court, without issuing notice on the plea, deferred the matter to 10th January. Let me tell you here that in 2022, the Supreme Court had ordered that the 152-year-old sedition law under IPC should be effectively kept in abeyance or temporary suspension till the union government reconsiders the provision. In an interim order, the court had also urged the centre and the state governments to refrain from registering any FIRs under the said provision while it was under reconsideration. This year in September, a 3-judge bench led by the CJI said that a reference to the larger bench was needed in the matter. And lastly, the National Consumer Disputes Redressal Commission New Delhi bench has held that when an agreement has an arbitration clause, the remedies of the consumer forums stand in addition to the Arbitration and Conciliation Act of 1996. In this particular case, the complainant booked a housing project in 2011 developed by Jay Prakash Associates Limited and its subsidiary JP Sports International Limited. The complainant deposited 54 lakh with the builder for the same. The possession, originally scheduled for June 2013, was delayed, and despite inquiries, the builder informed the complainant that the possession would be handed over by December 2015. Dissatisfied with the delay, the complainant cancelled the allotment in April 2015 and sought a refund. But the builder did not respond to his emails or a legal notice demanding a refund. Feeling aggrieved, the complainant filed a consumer complaint. In response to the complaint, the builder acknowledged the booking and deposits made by the complainant, but argued that the complainant was an investor and not a consumer. It asserted that the dispute fell under arbitration as per the standard terms and conditions of the agreement. The NCDRC observed that the builder failed to prove evidence supporting its claims. Citing various Supreme Court rulings, the Commission said that consumer forums exercise jurisdiction in addition and not in derogation of the Arbitration and Conciliation Act. Thus, the presence of an arbitration clause in the agreement does not bar the aggrieved party from approaching the NCDRC. Accordingly, the builder has been directed to refund the entire amount deposited by the complainant with a 9% interest from the date of deposit. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Livelaw. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.